Everybody comfortable, get seated, let me know if you're ready. Ready to go?
Good morning, Your Honors, and may it please the court. I'm Cheryl Codstring, have local counsel Stephanie here on behalf of Surgery Partners. We're here asking that the court reverse or overturn the circuit court's decision and remand the trial. This dispute arises from an insurance coverage dispute between Surgery Partners and its primary and excess insurance carriers. Here, the insurance policies at issue cover certain claims, specifically securities claims, that are both made against Surgery Partners and reported to the insurers within the policy period. We submit that the circuit court erred in precluding coverage under these policies as a matter of law, and in finding that there's no, or rather overlooking genuine disputes of material fact. In rendering its conclusions, including its conclusion that sealed QTAM lawsuits, that is whistleblower complaints filed under government seal, were deemed first made and reported against Surgery Partners.
Let me take you back a minute, because there's something there were two claims that were, well, there's two emails, right? We have one on the June 26th, one on the June 27th of 18.
So to frame the issues, Your Honor, the policy covers these securities claims that are first made and first reported. So there's really three requirements going on here. Are the QTAM lawsuits or the investigation securities claims? When were they reported? Were they first reported in the policy period? And when were they made against Surgery Partners? Your question speaks to when were they reported. There are two emails that are
reference two different policies.
I
believe you couched it as that the second email was a clarification.
That's correct. And
was it really a clarification, or was it an error that they referenced the 2016 and the first email on June 26th?
well, in the first email, and I want to make a distinction here. The policy covers claims made during or reported during the policy period, not necessarily under, right? The point is to
first made, which
first made it during, and those emails
2018 this time.
Correct. The emails were sent in 2018. That's during the policy period. The first email, while it does reference policies within the 2016 policy period, it also includes timeframes that fall within the 2018 policy period. So that first email was both sent during the policy period and also references a time frame or scope that's within the subject policy period.
Identical CIDs that were attached to it.
Correct. Yeah, identical CIDs were attached to both the first and the second email, which was sent the next day, as we visit, clarifying the correct policy period. So in the second email, again sent in 2018 during the policy period, we state with particularity that the notice is being given under the 2018 policy tower. It's identifying those policies by policy number and by policy period.
And why should we not hold as the trial court that the claim was first made or should have been made in 2017?
So that framing would require a finding that the CID, that's the civil investigation demands, are claims or securities claims under the policy. They are not.
Not claims or not security ones?
They are not securities claims. That's
Doesn't claim define, isn't a claim also a security claim? I think your distinction has to do with the investigation part of it, making it a security claim, and that an investigation is not a security claim.
That's correct. So a claim is the larger umbrella and is defined to include securities claims, among other things. The important piece here is that Surgery Partners is the claimant, the petitioner. They are the ones seeking coverage, and they're an organization. The policy distinguishes the types of claims that are covered for an organization versus insured individuals, insured persons. Surgery Partners cannot receive coverage for a claim generally, because a claim and a claim encompasses investigation. Surgery partners can only receive coverage for a securities claim, which is defined to expressly omit investigation. A securities claim is, for example, any regulatory or administrative proceeding, not including investigations. And so the CID, if noticed when received or hypothetically covered for an insured person, would not be covered for surgery partners. And so a big piece of this is saying, you know, a CID is an investigation, it's a claim against persons, any insured, right? Not this insured. And although you, surgery partners, as an organization, do not receive coverage for that piece, you don't receive the benefit under the policy for an investigation. We want to, speaking as an insurer, couch you with the burden of notice for this claim that you could never be covered for. And
how does that distinction though save you from exclusion D?
Exclusion D, the prior acts of exclusion. So in order to trigger exclusion D, there's a couple requirements. First, the claim, subject claim for which we're seeking coverage, which are the key TAM lawsuits and not the investigation, must be noticed in during a prior policy period. Again, this claim was noticed in 2018 via the email, and
also technically, because you have the 2016 prior email, you also have that claim.
Again, that email references both the 2016 and 2018 policy period, but also understand that there were insured persons involved. They're not involved in this litigation. So the notices were twofold. It's advising the insurers that there's a claim or investigation made against certain insured persons, but that there's also a potential claim or a notice of circumstances as to a claim against a securities claim against your profession claim.
That there was something coming down the pipeline.
That's the key TAM lawsuits that were inevitably unsealed.
And forgive me for sounding like an ignorant question. I don't have a lot of experience with key TAM litigation. Does the service of a CID, is that always precipitated upon there having been an underlying key TAM lawsuit having been filed somewhere? In other words, can a CID just be issued just because we're concerned about it, or does there have to be some kind of precipitating lawsuit filed somewhere?
I'm perhaps equally ignorant as to when a CID is used. I know it is often used as a precursor to key TAM litigation. I don't believe that to be its only function. Civil investigation, it's essentially a subpoena for document production.
Right, which usually the government doesn't get to just get your documents or force you to hand over stuff unless they've got some kind of constitutional authorized basis for doing so. And that's why I'm trying to tie that together, because that seems to me to be a very significant step by the government, which would seem to me analytically to tie the two, the key TAM lawsuit and the CID, a little bit closer together, if in fact one is dependent on the other for its existence.
Sure, there's a relationship between the two documents. The problem here, or important fact, is that the policies are not triggered until there is a claim made, and the CID expressly for the policy language is not a claim against surgery partners.
Not a securities claim, because it's not a securities claim.
It's not a securities claim against surgery partners, that's correct.
So what was the effective date of the policy at issue here?
April of 2018 through 2019, I believe April
And
1st.
all the claims made were prior acts? Is that what you're saying, or a continuation of the claim made prior to the effective date of the policy?
No, so the effective claim, the claim for which we're seeking coverage, are the key TAM lawsuits. The key TAM lawsuits were first noticed to surgery partners in February of 2019, so within this policy
Prior
period.
to the effective date.
No, during the effective policy period. Our position is that the key TAM lawsuits, these sealed complaints, which became unsealed and noticed to surgery partners within the policy period, February of 2019. That is the subject or operative claim for which we're seeking coverage, and it was made within the policy period. and also reported.
Claims made shouldn't be just confused with prior claim. The claims made during the policy period is a covered issue, correct?
That's correct. The other piece to answer your Honor's question of the prior notice exclusion is that the claim must have been accepted. In order for coverage to be excluded, the claim must have been accepted during a prior policy period. That was not the case here. In fact, the insurers expressly accepted coverage under the 2018 policy period. So they did not accept coverage under
At that point in time, they then accepted coverage under the 2016.
2 years after the claim was initially tendered and after multiple coverage positions were issued by the insurers. And so at a minimum, that timeline of the insurers saying expressly, we accept and we acknowledge coverage under the 2018 policy. And then 2 years later saying, oh, actually, and this is
Let me ask you, the insurance company, I just can't recall off the top of my head, have they provided defense coverage during the
No.
investigation? They have not.
no.
Okay.
And 2 years later, they assert, well, this would have been better noticed under the 2016 policy. Again, an admission that it was not noticed under the 2016 policy, but would have been better noticed. And therefore, the insurers, when they switched position, said, nevertheless, we'll accept this as notice of a claim under 2016 policy. I think this first, changing positions 2 years after a claim is tendered, there's estoppel waiver arguments, right? An insurer is not permitted to sit on information known to it and withhold defenses to coverage for years and then suddenly raise them on the back end. But also under a summary judgment standard, this raises genuine material disputes of material fact, right? When was the claim made? The insurers themselves can't even figure it out. And that's not only true for the lead insurer, the primary insurer, who's the one changing positions, but also the excess insurers. At the lower court, during our MSJ hearing, one of the excess carriers attorneys spoke out to say, and loosely quoting, various insurers have taken various different coverage positions as to whether the 2016 or 18 policy applies over time.
Does any of that matter where the allegations that were alleged preceded the runoff time? So was that October 1st, 2015, when surgery partners became their initial public offering? And so it alleged the consistent policy of illegal false claims, right? So how, and all that is really interesting argument, right? But how does this exclusion, which is what 5M, not just dispense with all of that?
So if this is a factual inquiry, right? In order for this exclusion, the prior acts exclusion to apply, the claim, every wrongful act alleged in the PTAM lawsuit must be related to some act taken before this 2015 runoff
But
period.
if it was a continuous policy to illegally file, to have all this lab work done, right, on every single case. Are you saying then that they would have to prove that it's their burden, because these are exclusions of obviously the insurer's burden here, that they would have to prove each and every wrongful act?
That is
That it's a continuing illegal act?
Yeah, that is our position. The common scheme approach or chain of events approach has been expressly declined by what we purport to be binding authority in Tennessee. We assert that Tennessee law applies. But even if Your Honor didn't want to stretch it to that magnitude, right, that every single bill must be related to some other bill back in 2015, it's important to understand the allegations and the different allegations against surgery partners. There were false claims acts alleged, but also anti-kickback allegations. These are just two of many examples. In the
But a
end,
whistleblower complaint didn't individuate each and every separate instance, it alleged them as a general, basically as a general violation, right?
well, we're talking about,
Under different state enactments of different, but I mean, they didn't, this isn't a 700 count, civil action.
well, the complaints did call out the fact that in order to determine whether a violation has been committed, it's a separate and individualized approach as to each and every bill. In fact, imposing penalties under the False Claims Act requires such an inquiry. Every single bill must be pulled, and often these cases get settled for some lump sum too.
I don't mean to interrupt, but it's down to 4.5. Do you want to keep going?
I'll reserve time. Thank you.
Morning, Your Honors. Joseph Finnerty for the defendant, appellees, National Union, and the other insurers. Your Honor, I think Your Honors, I think it's worth going back and understanding at a fundamental level what we're talking about when we're talking about three separate and independent bases for denying coverage on the 2018 policy. And what it is that we're talking about, that is the nature of the claim made against this insured, both individual insurers and surgery partners. The claim that is referred to in this claims first made and reported policy is a claim made against the insurers, not the insurance claim made to the insurance companies, which you've heard counsel talking about with those notifications. The coverage provided under claims made and reported policies is the claim made against the insured. In this case, we're talking about a key TAM lawsuit that began with two separate complaints in two separate states in 2016 and 2017. As a result of that key TAM lawsuit being filed under seal and delivered to the government makes a determination after that to decide whether or not they're going to pursue an investigation. After that investigation is determined, one that the government wants to do in this case, in 2017, in October 13th, 2017, the government issues CIDs, civil investigative demands, publicly to surgery partners and to two individuals at surgery
So
partners.
help me, follow me with, I know where you're going with
Okay.
it. So follow me with the definition, because in, I think it's BB under the definitions, investigation, it includes a civil investigation demand, but yet in UU where securities claim is defined, it says a claim other than an investigation of an organization.
That's right.
So I know your position is to hold that the claim was in 2017, but explain the distinction, which seemed to be conflicting with your argument.
Happy to do it, Your Honor. In this case, what we're talking about is a claim as defined in the policy. When was a claim made against, and the words in the policy are important here. The insuring clause of the policy says that the 2018 policy, which is the policy we're talking about, provides coverage, and here's a quote, solely with respect to claims first made against an insured during the policy period. That means you need to have a claim first made against an insured under this policy period in order for there to be a claim. In this case, as Your Honor was clearly pointing out, the definition of claim includes an investigation of an insured person. In this case, the CIDs specifically named two individuals, Christopher Doyle and Christopher Tepke and Michael Doyle. Both of those individuals are insureds under the policy. The investigation notice to them is a claim as defined in this policy. Therefore, the claim was first made against an insured in 2017, October of 2017, when that CID came. It was actually a claim made during the key TAM complaint, but they were filed under seals. That's a little bit different kind of an argument about whether a claim was in fact made against an insured in a sealed complaint, whether they knew about it or not. There's an argument that it would be a claim, but we're not making that argument, because the CID is a publicly made notification.
And so National took that position 2 years later.
National took that position when in response to two different notices, one made under the 2016 policy, and Your Honor was very clearly on the point of that, and I'll get to the prior notice exclusion. But the notifications came from a broker AIG, the National Union, the insurance company in the lead of the tower, responded in due course at the back and forth. There is no basis for an estoppel argument, Your Honor. The notification came in under the 2016 policy. National Union responded to that notification of the 2016 policy and said, we accept your claim for coverage under the 2016. Counsel's incorrect in her statement that there was no acceptance of defense costs. As a matter of fact, there was an offer to pay the defense costs in correspondence for those two individuals who provided notice of the CIDs under the 2016 policy. The problem was getting to an allocation of the defense costs. The insured did not want that coverage. They wanted coverage under the 2018 policy. They didn't pursue that. So there's no final checks were not written for defense costs. But there was a claim under the 2016 policy. It was claim for insurance coverage sought under the 2016 policy. So under the prior notice exclusion, they notified it under the 2016 policy. This is the second defense to coverage. National Union accepted the coverage. That policy was, the policy they're seeking coverage for now is a renewal or replacement of that very policy. And it's the same claim. So that prior notice exclusion, which says under the 2018 policy, there's no coverage if you provided notice under an earlier policy of which this is a renewal or replacement, and the insurance company accepted coverage under that policy, and it's the same claim. There's no coverage under the subsequent policy. It makes entirely good sense.
So it can't be the same claim if in one part of the policy, the particular type of claim vis-a-vis the insured is specifically excluded under the precipitating claim that got the whole thing started. Because that's what I'm trying to understand. At a certain level, this gets really meta. I mean,
I understand, Your Honor.
more you follow that. It's a securities claim insofar as we're considering coverage, but not for purposes of whether the timing of when the claim is that.
Your Honor, it's a claim made against all of these insureds, whether it in fact, it's a complaint. Whether it's a claim under the policy is a different thing. It's a complaint made, therefore a claim in the world that we know it as claims aside from insurance, made against all the insureds, against surgery partners, the individuals, all of those lab companies that are affiliates of surgery partners, all of those entities had claims made in the world at large against them.
That's the CID.
That's right. Well, when did it become a claim under the insurance policy against an insured, which is what's required for the policy? That happened when the CIDs were issued to individuals, and the investigation against an individual anchors that claim at the time it becomes a claim under the policy. And that's on October 13, 2017.
Regardless of whether there would have been coverage for surgery.
That's correct. Whether or not there happens to be coverage for any insured under the policy, when was the claim made against an insured is the question. That anchors the whole claim in that policy period. So you're stuck in that. That's just the way the policy works. You can't try to trigger a number of policies. That's the reason for these rules, is so that you anchor it in a place and time when a claim is made against an insured, as long as it's the same claim. And in this case, undeniably, it is the same claim. There has been a perpetually consistent allegation against all of these defendants that they willy-nilly took a urinalysis of every single patient.
To clarify for me, something the opposing counsel stated that the claim was first accepted by National under the 2018 policy first.
No, it was not. It was the accepted, meaning the only acceptance was an acceptance of the defense cost coverage for the individuals who were investigated. That's the acceptance by National Union and the insurers. There was correspondence back and forth about what the nature of it is. As Your Honor correctly points out, this can become meta and claims people in different policy periods, maybe get it wrong. The question is whether or not it's gotten right now. And for three reasons, there's no coverage under the 2018 policy, but there is coverage under the 2016. The first is the claim was first made during the 2016 policy or before. The second is the prior notice provision exclusion that we've just been talking about. And the third, which I haven't gotten to yet, is the prior acts exclusion. And under that exclusion, this policy was issued to a company that had gone public on October 1st, 2015. And a decision was made, we're not going to cover any claims that arise out of this company's pre-going public world. Therefore, if a wrongful act is alleged in a claim made against this company prior to that going public date, any claim that arises out of that wrongful act will not be covered.
The national changes defense strategy, let's say, based upon what your opponent has said, they changed midway through, several years later, they made a change, and if you can't do that, there's waiver and estoppel.
No, there's no argument about it, waiver or estoppel, that anybody relied upon and acted upon anything that any insurance company said here. In fact, the only thing is National Union and the other insurers said we were going to provide coverage for these individuals, and they didn't take up the gauntlet of getting that quantified. But it's just a matter of back and forth. Nobody changed their position or is equitably stopped by anything that was done by the insurance.
The exclusion, if I understand this correctly from what you're saying, is that because they accepted the claim for 2017 that was against the individuals, the two individuals. Therefore, they're not going to pay on any claim made against surgery partners.
It's not a question of not going to pay. It's what do the terms of coverage dictate with respect to surgery partners. And
The insurer will not be liable to make any payment for loss in connection with a claim made against an insured. And then it talks about exclusion D, alleging or arising out of base attributable back alleged in the claim. The same way.
That's right. That means, I'm sorry, I didn't quite understand your question the first time. The 2018 policy will provide coverage for no insurance. No insurance. It's saying you already sought coverage under the 2016. We accepted coverage under the 2016.
But that can only be for the two individuals. Or you're
No,
saying it's for
it's a claim for all insurers, and the terms of that policy dictate what coverage is available for surgery partners, for Forest Labs, for all the subsidiaries that might have coverage under this, any other insurance. It could be other individual insurance. They're just cabined in the anchored policy, which is the 2016 policy, because we accepted their notification under that. The claim was made.
can't hit two policies.
Exactly. And then just to tidy up that last piece, the prior tax exclusion is per force applicable here, because this is clearly conduct that started in 2012. And in the settlement agreement with the government, they memorialized that the wrongful acts that are being settled started before October of 2015, which is the prior acts, the prior wrongful acts date. So since the claims are all the same from the beginning to the end, just doing these urinalysis without authority, there's no difference in the wrongful acts of the defendant. It's not a question of whether or not any patient did something wrong that can be distinguished between different patients. It's whether the same conduct, the same wrongful conduct was in play. And it's a simple act that's been done. It's repeated over and over since 2012. They took urinalysis when they didn't diagnose the need for urinalysis, and that was considered a false claim. That's what happened from the beginning to the end. So the wrongful act all started in 2012. They should be excluded of that prior acts. I don't know if I have any more time, but if the court has any questions, I can't reserve time because I'm in a.
That's right.
Thank you.
Thank you. Very well done. All right, let's go back. You have 5 minutes.
I'd like to close with some quotes and statements from the insurers. First addressing the question, is a CID a claim? In their coverage position letter issued November 2019, insurers say, quote, because the basis of this matter was the receipt of the CID and ensuing investigation, the claim does not fall within the definition of securities claim. Prior to that, in 2018, their coverage letter asserts that the subject CID does not trigger coverage because, quote, no claim, not securities claim, no claim as defined by clause 2 definitions has been made against an insured at this time. Regarding whether coverage was accepted during the 2016 policy, as opposed to the 2018 policy, the insurer's September 2018 letter states, quote, we will accept this matter as a potential claim or notice of circumstances pursuant to the 2018 primary policy. The letter does expressly call out the 2018 policy and state, quote, we will accept. In their November 2019 letter, they state that they, under the analyzing only the 2018 policy cited in the caption of that letter, insurers state, quote, they agreed to accept the notice as a claim with respect to Surgery Partners executive officers, again, 2018 policy. Regarding this notion of an insured receiving notice of a claim or a claim made against an insured versus any insured, I know that the foundational principle of a claims made policy is that the insured is aware of the claim against it. If you impose this idea of a claim made against any is a claim made against all, you disrupt that principle. For example, here, Surgery Partners is an umbrella, a parent company to several of the subsidiaries that were named. If the opposite were true, if Surgery Partners were named but not its subsidiaries, those subsidiaries might not have notice of its parent company having been sued or having.
But don't we have to look to what the definitions are of what an insured is, and it encompasses both the officers and then it also encompasses the entity?
The insurance policy has two separate definitions. It does define insured, which includes insured organizations and insured persons, but then the definition section further breaks out who is an insured person, who is an organization. And the base insuring agreement that dictates coverage has separate coverage parts, A, B, C, D, etc. A, and I don't recall the exact sections, but say A applies only to organizations and says we cover organizations under coverage part A for securities claims. Under coverage part B, it might say we cover insured persons for all claims or pre-claim inquiries, which include investigation as distinct from the prior coverage part.
You have about a minute and a half on your vote.
So I just underscore that this is a contract like any other. It's an insurance policy, yes, but it's a contract. And what we're here to determine is whether the insurers had an obligation to provide coverage and whether there's any factual dispute given the meta of information at bar as to whether they do or do not provide coverage. And it's not simply that a claim is made or it's first reported or it's any of these factors. All three must be present and there must be no dispute, no factual dispute about all three of those in order to trigger the insurer's coverage obligation. It's not just that we have a securities claim or that it was made at a certain time. And so all three of those must align, and they don't here, and they certainly don't beyond any dispute of material fact. So we have Your Honor's to reverse.
All right, well done, well presented, well argued. Safe journeys back to your home. Thank you. I will be in recess.
All rise. Thank you. Travel safely.